When we have to look at the secondary sources of Indian law, we look at two sources. The first one is justice, equity and good conscience, and the second one is the sources of English law. Now, what do you mean by justice, equity and good conscience? This simply means that in the absence of any statute, legislation, custom, personal law, etc., which we call as our primary sources of law, in the absence of all of these things, if the court is presented with a situation whereby they have to provide some form of justice to the parties approaching before them, they will sometimes use good conscience, common sense, principles of justice or principles of equity while applying the providing some justice before to the parties that approach them. So, in the absence of primary sources, the judges can give what they deem best for the parties before them. The second source of secondary sources are your sources of English law itself. Now, what do we mean by this? Generally, we can say that in India, all of our laws have come from the English, or at the time of our annexation by the British, or when we were under British rule, it was the Britishers who came and set up our legal system as we know it today. And so, all of our laws follow the same lines of reasoning as that of English law. And so, if our laws are silent, or we do not have any principles or opinions or customs or legislation for the same, then we can reference the common law that is belonging to the English law. So, what exactly is common law? Common law is a set of principles which have been followed over a period of time. Okay. These principles have been brought over by many years and denote all the legal rules which consists of customs, judicial decisions, textbooks on jurisprudence, etc. So, these are principles which are made by whom? Principles made by judges. Over time, that includes their interpretation of law. So, this is one excellent example of the sources of English law. The second one is known as the law of merchant. Now, law of merchant is relating to all those customs and usages which traders have used for time immemorial. And these customs and usages will end up having some form of universal compliance. In such a case, that custom or that usage ends up becoming the law of merchant in cases of trade relationships. The next one is the principle of equity. There are two principles of equity over here. They are saying that he who seeks equity must do equity, and he who comes to equity must come with clean hands. So, this essentially means that when a person is approaching the court of law, again remember there are no primary sources, which is when we refer to the principles of equity. What is equity? Equity is saying that you can divert from the existing general rules and apply a certain principle so as to provide the best form of justice in this matter. And so, we can say that the principle of equity is a form of justice which is enacted to persons who come to the court with clean hands, which means that if they are seeking an alternative remedy, then they must not have dirtied their hands in the process. That means they must not be guilty of actually doing that work. So, generally they say that when a person is expecting a principle of equity to apply to them, then he must come to the court with clean hands, and those who do equity and those who seek equity must do equity. And lastly, statute law, that is those laws which are enacted by parliament or subordinate or legislative authorities. Now, as you can see over here, let's expand on the concept of the principle of equity. Sometimes they are saying that there is no remedy or inadequate remedy under common law, in the sense that every time there was a dispute, it was the king that would hear the matters of the parties, and when people were dissatisfied with the decision of the king, of the common law court, they could always file a mercy petition with someone known as the king in council. the king in council would refer the petitions to someone who's known as the chancellor. The chancellor belonged to the church, and sometimes this church or the chancellor would dispose of petitions without even following the proper letter of law, but he would rather use common sense, natural justice and good conscience. So I can say that equity is a form of alternate remedy which was provided to persons who were dissatisfied with the decisions given by the courts. And so this remedy given by the chancellor was known as the equity court. But they were also very clear about it. If such an equity court was departing from the existing laws or was not following the rigid letter of the law, then it would only apply to those people who come to the equity courts with clean hands. They must not try to get a remedy. I'll rephrase this. If a person has committed some kind of an offense and the highest court or the common law court has convicted this person of the crime that he has committed, this person cannot approach the chancellor seeking an alternate remedy if he has actually committed the wrongful activity. And this is what the principle of equity says. Now we come down to the concept of mercantile law, commercial law. We see that mercantile law is found in many aspects of our existing laws, whether it's a civil and criminal laws or whether it's administrative and constitutional laws. We see that mercantile law is a very integral part of our society. So let's try to understand what the sources of mercantile law are. One is law of merchant, statutory law, common law, and principles of equity. So mercantile law in India has grown over a period of time. One, it has been regulated by customs or the personal activities of parties. But if there was any wrongful activity or a dispute which needed to be heard, then it was usually governed by the personal laws of the people. However, this proved to be more problematic than a solution, and therefore a lot of effort was made to codify the principles of mercantile law, and the Indian Contract Act was enacted. Not just the Indian Contract Act, but Partnership Law, Sale of Goods Act, Negotiable Instruments Act have all been legislated at some point or the other. So let's try to understand what exactly the sources of our Indian mercantile law are. First and foremost, we have English mercantile law, because like I said, we gain a lot of our laws from the English. We have been dependent on the English for a long time for our trade practices or even to engage in trade. And so therefore, since our laws are dependent on English mercantile law, that in the absence of Indian laws, we can always refer back to the English mercantile law. The second one, it is any law passed by our own parliament. So like we just said, we have the Indian Contract Act, the Sale of Goods Act, Partnership Act, Negotiable Instruments Act, the Arbitration Act and the Insurance Act. And wherever there are laws, we can say that there will also be judicial decisions. So the judge normally has to apply the existing law to the people, but if he believes that he has to give an interpretation of the same, and if he believes that there must be a clarity given on certain statutes, then he may decide the principles in accordance with the rules of interpretation. And these interpretations are known, or these interpretations or decisions are known as precedents, and they become an important source of law. Our judges also have the capability to depart and apply justice, equity and good conscience if they believe that there is no law in existence for the purpose of this, for the purpose of any dispute that comes before it. Customs and trade usages. A lot of our customs have already been codified or made into a law, but we have not completely given away the use of customs and usages. And so if you look at some of our existing commercial laws, that is, if you look at the Indian Contract Act, or even if you look at the Negotiable Instruments Act of 1881, they use a certain they use a certain sentence. They are saying that nothing contained herein in these laws, that is, we are talking about section 1 of the Indian Contract Act, is saying nothing herein contained shall affect the provisions of any statute, act or regulation, not hereby expressly repealed, nor any usage or trade or custom, nor any incidents of contract not consistent with the provisions of the Act. So, this has a lot of negative connotations in the sentence. Let me rephrase it for you. This law will be subjected to any kind of usage, trade or custom already in existence and which has not been repealed. Okay? And if this law comes in, it will not affect any usage, trade or custom. So, in the sense that even though this law is in existence, if there have been certain customs or trade which have been followed over a long period of time, this law will not affect the implementation of that custom or trade. Unless, of course, that custom, trade or usage has been repealed by law or has expressly been banned by the law. So, in essence, what are they saying? This law has come into force and it will not affect any kind of usages or trade or customs that has already been in existence for time immemorial. And the same thing applies even to our Negotiable Instruments Act. So, we can clearly say that the law is trying to work in consonance with the existing trade customs and usages.